with me. How's that?
All right, thank you, Shane, and good morning again, ladies and gentlemen. I'm very happy that we're going to close today's program with a superb panel of practitioners, people who have been trying serious criminal cases in our district and superior courts for a number of years, and who have dealt directly with the issues that you've heard other panelists talk about at the back end of the process, you might say, after the police investigation in most cases is over and the drama moves into the court. But first, I'd like to just acknowledge the presence this morning of a colleague and a friend, Judge Joe Dever from the Lynn District Court, who was truly the inspiration for this program. We talked about it a number of months ago, and with the help of Professor Rudnick and Professor Malaguti, we were able to put it together. So I'd like to acknowledge his contributions and his presence. Now, I'd like to first turn to a point that my good friend from Worcester, Tom Landry, made. Do we have a problem? After all, we'd like to think of our Commonwealth of Massachusetts as a very progressive state. And in this area of criminal procedure, there are a number of features of our law that are different than the federal law. After all, we do promote video conferencing or videotaping and recording of custodial interrogations. We do have the humane practice, which requires the judge and the jury to look at voluntariness when that issue is raised. And importantly, we tell our judges that you have to find that a confession is voluntary and that Miranda rights have been waived by a standard of proof beyond a reasonable doubt, unlike the standard of a preponderance of the evidence required by the Supreme Court. So with all of that, do we really have a problem? Well, I think that the police representatives who were here this morning are the creme de la creme of the law enforcement community. They're honest, they're students of the law, and they approach their work with a degree of healthy skepticism. I think that came through in their presentations. But not all police officers, unfortunately, approach their work the same way, and particularly approach custodial interrogations. As the prior panel said, custodial interrogations are guilt presumptive events. That is, at the time of a custodial interrogation of a person who's been arrested, the police have come to the conclusion that that person is guilty of the crime in most cases. That's what the literature says. That's what the interviews and the surveys say. So depending upon the individual interrogator may determine the extent to which that individual is going to be treated in terms of whether or not they will be afforded the full opportunity to exercise the choice they have about whether or not to speak or not. And so to the question of do we have a problem, I think it's more appropriate to say, can we do better? Now, more particularly, one might ask, have we here in Massachusetts ever experienced anything like what some other states have experienced in terms of false confessions? Because this is a fairly recent phenomenon. Well, there's at least one case that's been documented as a wrongful conviction in which a confession was admitted that was deemed voluntary by the judge, deemed voluntary by the jury, and led to the conviction of the defendant, who served 7 years in state prison before being exonerated. And that was the case of Marvin Mitchell. And for those of you that want to read a little bit more about it, I'll just give you the citation and then the reference to where you can find the story behind the story. The citation is 35 Mass Appeals Court, page 909, a 1993 case. So this isn't a case from the 50s or the 60s. He was convicted of a sexual assault of a young girl, and he was not only misidentified, but a confession was admitted that obviously, in retrospect, was false. And the details can be found on the website of the Innocence Project that's been referenced. It's www.innocenceproject.org. So with that background, let me turn to our distinguished panel. And let me ask to my left an experienced criminal defense attorney here in Essex County who has tried virtually every kind of serious criminal case, Ronald Ranta. In view of the solid evidence that we now have that at least some innocent people will confess their guilt, is it time that we should forbid or outlaw the intentional use of false statements by police interrogators?
Well, I can see how the police will think that that's an effective tool, because the innocent would no doubt say, well, you're presenting, what were you to say if we found your fingerprints or your DNA at the crime scene? The innocent would always say, oh, well, you're wrong, go ahead. And I've had some cases where clients were confronted with that and they insisted that, well, you got a mistake. They, unfortunately, were all guilty. But I think it's a matter of perspective. I can understand from the law enforcement's point of view, their attitude is the innocent will always exonerate themselves. Having come at it from dealt with clients, one of the things that struck me in listening to the panelists this morning from the police perspective is describing their interrogation rooms, and all of them were similarly, laid out. And I thought, geez, that's pretty neat. They all got the same interior decorator. And then I realized they did, and that interior decorator was designing rooms that were specifically designed to encourage them to talk, to encourage them to give what the police wanted. The police come into it with a preconceived notion. As Judge Agnes said, this is a guilt confirmation interview they're going to have, not an interrogation to discern what happened. Most investigators, most good investigators, probably feel that they have figured out the case by the time they're talking to the individual. They have gathered enough physical evidence, they have enough background that they have some preconceived notions. Indeed, Chief Tucker indicated how he will determine who he thinks is the least culpable of the two and then engage in a pattern of conduct that is designed to have the other individual think that his buddy has just thrown him under the bus. What does that convey to the individual? Does that convey to that person, look, here's an opportunity for you to tell me what truly happened? Or what has he really done is, I'm giving you a roadmap of how to go from point A to point F, which is freedom. You want to take it? Your buddy just threw you under the bus. What do you have to say? Well, he's then going to say, it was him. What you've given them by that preconceived, you've given them a preconceived notion of how to exonerate themselves. So what they're getting, they think, is going to be proof that will be used to convict the person they believe is more guilty. But what may, in fact, be nothing more than that person confirming what the reasonable inference they got. They read it's a two-way street. It's a dynamic, fluid situation where the police officer's trying to read what is it the person giving to me. Same token, my clients are trying to read what is the police officer giving me. Is he giving me these are desperate people. There's no knickknacks in the room for them to look around. The doors are closed. Literally and figuratively in their moment at that life. They're fearful that that door will never open. They have now been thrown a lifeline that they believe will get that door open. And they've been given the key. They're going to take that key, and I think it will lead to a lot of, I think they should be outlawed for that reason because of the preconceived notion. Now, I think the onus on that rests on the defense bar to point that out to courts, to make courts come to that conclusion by constantly hammering that home. So at this point, if I'm in law enforcement, I'm going to use it because it's successful. If you can, they're going to, equate success with not having the statements thrown out, not having the confessions thrown out, and gaining convictions on crimes, closing them. And if I'm in law enforcement, I'm going to use that until I'm told I can't. And I think the onus is on the defense bar to get the courts, the appeals courts, to tell them, no, you can't.
Let me ask that question of another panelist, Jerry Shea, who anyone here in Essex County knows is a senior member of the District Attorney's Office, has also tried virtually every kind of felony case there is in both the district courts and the Superior Court, and is one of those people in the office who young assistant district attorneys go to for advice, and who perhaps is also sought out by the police for advice. Does the district attorney, Jerry, get involved in educating police departments about some of the things that are more likely to produce confessions that are going to withstand scrutiny in the courts? And if so, is your office involved in counseling the police with respect to this practice of suggesting that there's incriminating evidence when perhaps there isn't?
Well, in terms of talking about changes in the law, certainly there are procedures set up when there's a new case that comes down. Our office does get involved in communicating with the chiefs of police for the county to explain what the status of the law is as it's changed. But most of the interrogation type guidance, if you will, comes from individual ADAs and the police officers that they're working with on cases. My experience is that, and I think that Chief Tucker sort of alluded to this in some of his examples, I don't think the police generally use false information in their to elicit confessions from people. I think what they do is they present them with possibilities, and that might be some carefully phrased question like the chief was talking about the potential of a video camera, even if there's one that is not there, but not misleading them, directly misleading. More often, I think what they do is they ask about the possibility of DNA evidence being at a location or on an object, and they may explain that how DNA can be identified, even if there's only been casual contact with things. And I don't think that is a problem, personally. I'm not sure if I'm drifting off on your question, whether I think it's bad to do that or not.
Well, do you think it would be a detriment at all? Because I think that one of the balances that we're trying to strike is not to make changes in the law or propose changes in the law that would forbid or outlaw custodial interrogations or make them totally ineffectual. On the other hand, make sure that people have the right to exercise the choice that the Constitution says they have between speaking and not speaking. And so the question is, would the hands of the police be tied in any way if we simply were to say, during a custodial interrogation, you cannot make intentional misrepresentations about the facts of the case or the evidence that you may or may not have?
Well, I think that'll generate a lot of litigation about what was said and how it was said. And just to harken back to what I was just talking about the way the information is presented, I think a bright line rule that you can't give false information to the suspect is probably a good idea. I think the SJZ is already indicating some disfavor with those kind of confrontations now. If you tell a suspect that the person that we just talked to 10 minutes ago said you were the guy that killed the person, when that is completely false, when the interview with the other person revealed no such information, I think that's a problem. And I view that as a prosecutor, as a lawyer. I mean, a lot of you are defense lawyers, but the ADAs are lawyers too, and we have to go into court and we have to talk to the juries, and we have a credibility issue as well. And we don't want to be advocating for them to accept basically material that's been unfairly or in a sort of a distasteful way, the way it was obtained. Our case is going to be presented in a way in which the jury is going to accept the evidence that we give them and believe it. And if they feel, for one reason or another, that the police were not fair, in one particular instance, it may color their perception of the entire investigation. So that's sort of a selfish view I take. We, I think, share a lot of common interests in the way evidence is obtained, on both sides of the bench. Many defense lawyers were on my staff or on other counties' district attorneys' staffs at one point in their career. So I think we have a common perspective as lawyers. So that's my feeling about it. I think that a bright line rule, if they tend to talk about things for a long time before they make a decision finally, like DG and Batista. And personally, I would much rather that they make a decision right away and say, this is the rule, and you should follow it. And almost all the police work in good faith. And when they understand what the rules are, they strive to follow them. And if it's fuzzy, then they feel that they are entitled to operate in a broader spectrum. And so I put it on the SJC to be clear about what we can and we can't do so that the word can get out. And so, I mean, that's what we argue about in court. That's what the motions to suppress are all about what's voluntary, about whether the statement was false or whether I just characterized it in a different way. So
Denise Regan is known perhaps to many of you. She is a senior trial counsel with the Committee for Public Counsel Services, has not only tried felony cases of all kinds at all levels, but has instructed and mentored hundreds of lawyers who have learned their craft as either employees of or counsel with the Committee for Public Counsel Services. Denise, is it time, in view of what we've heard this morning about the phenomenon of false confessions and the potency of psychological interrogation techniques, is it time for some new rules, some further line drawing by the Supreme Judicial Court? And if so, what are some of the things that perhaps should be done?
Well, Jerry and I are in agreement that false lying to the suspect to get the confession should not be permitted. And for me, it's both because it's shown that is a technique that is more likely to elicit a false confession, and also for me because it really offends a sense of fundamental fairness of the integrity and ethics of the whole system when the police are able to apply lying. But as we heard from Chief Tucker, who I've known for a long time, carefully phrased questions can imply a lot that isn't said outright. And it's a difficult thing after the fact for the court to decide if it's gone over the line. So I am very much in favor of mandatory recording of all police investigation from beginning and end. What has happened is, because of the wiretap statute, police departments are leery of taping without consent, and so there's a form. And defendants think, well, if they're not taped, they can't use it against me, and they decline to be taped, when in reality, overall, I think having it taped is the best thing. Excuse me. Because the police officer's memory is not going to be completely accurate, because the police officer is not an objective observer of the interrogation. The police officer is in the interrogation playing his or her role, operating from his or her perceptions and assumptions, and may inadvertently say things or may remember that they phrased the delicate question one way when actually they did it the other. Plus, a police officer with all good intentions can conduct an investigation and get a confession, but when you look at the totality of the circumstances, which is what the court looks at, because of impairments of the defendant that might not be obvious, and because of the effects of the questions and the way the questions were asked, actually elicits a false confession. And it may actually be an involuntary confession, but not because of bad will necessarily of the police officer, but just because we're all human. So I would urge the SJC to first and foremost require that confessions be taped, interrogations be taped from the beginning to end, because one of the things that you see in false confession cases is that the scripted confession is taped, but all that led up to it is not. And it's all that led up to it that's important.
Now, ironically, we're talking about the potential for more rulemaking or greater restrictions on the use of certain kinds of interrogation techniques. And yet, at the level of the United States Supreme Court, some say that the court is prepared to inter the Miranda case entirely and simply go back to the case-by-case voluntariness test as a result of several decisions in the last term. Let me ask Ron, do you think Miranda is headed for that end? And if so, what effect will it have on proceedings in state courts like Massachusetts?
Well, I think it is heading in that direction, and I think it just depends on who the next Supreme Court justice to retire is, on which side of the aisle he is. I mean, it's pretty clear how the SJC has been stacked now over the past, well, actually 100 years. They've gone through different stackings, and we now have a stacking that is likely to lead to it being undermined. I see, quite frankly, as far as Massachusetts, where I do my practice, interestingly, is going just the opposite direction. I think, if anything, the DG and Batista decision has revitalized not only Miranda but the voluntariness issue. I've had cases where my clients' confessions have been taped, and I know when I get the report about if it was just a report and it wasn't the tape. I had one case in particular where my client made a complete confession. It was a fairly overwhelming case. They read him his rights, and they engaged in some conversation. He went on, he signed a waiver and everything. And then I watched the recording, and at the end of the standard rights, having all these rights in mind, do you wish to continue to talk to us? And the guy said, no. And the officer, because it had gone pretty well up to that point, was kind of taken aback. He said, well, you sure this is your last chance? And my client, oh, it is? Oh, yeah, you're going to get a lawyer now. He's not going to let you talk to us. This is going to be your last chance. Well, let me tell you, I really did it. And he went on and I know, had that not been taped, the police report would have we read him his rights, and he signed the voluntary waiver, and he gave us this full confession. And I also know that my client never would have remembered that subtle little no, which was pretty good for me. But as a result, the confession was thrown out. He still has a daunting task because there's overwhelming evidence against him. But that indicates to me that in Massachusetts, we will have the capacity, because of DG and Batista, to have those nuances, have those subtle moments that your clients will never recall, that we don't have to litigate. There was no he said, she said. It's on the tape. The district attorney's office argued that my client's indicated a real ambiguity, and that you really can't trust that no after the and that this really was kind of an equivocal. Thankfully, the judge didn't see that equivocation. But so I think we're in Massachusetts, because of DG and Batista, going the other way, where we have strayed from the federal government on a number of paths. I think our two paths diverged in the wood, and we're taking, thankfully, the one perhaps less traveled, but it's one that I think will lead to a sounder constitutional footing for all of our clients.
Let me ask Jerry this question. Now that we know that at least the phenomenon of false confessions isn't just theoretical, it's happened, and it is happening. As a prosecutor, when you are preparing a case and you get reports, whether there are videotapes or not, of custodial interrogations and statements made by defendants, do you approach the assessment of the evidence any differently? Are you more skeptical? Are you looking for corroboration where you might not have looked for it before? Or are you primarily looking at the case as a whole and the officers who were involved, as you might have over the years?
Yeah, I don't think that personally I've changed my perspective because of this discussion about false confessions. I'm a fairly critical person in terms of the evidence. In my office, the district attorneys don't get involved in the investigation except in some sexual assault cases and in homicide cases. So we don't supervise directly what the police are doing, and 99% of the prosecutions that we get it after the fact. We may expand on the investigation in the grand jury, but basically we're not on the ground floor talking to the police as they're proceeding. In homicide cases, we do discuss with the investigators the quality of evidence that we have in relationship to the entire investigation, whether or not we have enough, whether they should talk to other people, whether a particular interview is valuable or not, or reliable or not. And so in that sense, and I think that's probably generally true, we have a view of beyond a reasonable doubt, not do we have probable cause to arrest. It's a different perspective that lawyers have compared to police officers who are involved in investigations on their own. So when the ADA's guiding it, the ADA's thinking, do I have enough that I'm going to convince 12 people beyond a reasonable doubt of the elements of the crime, not do I have enough to arrest this person.
Denise, as you know, at the federal level and in most states, the law requires only that the government prove a confession is voluntary or that a defendant waived Miranda rights by a standard of a preponderance. In Massachusetts and a few states, that burden is beyond a reasonable doubt. Does it make any difference in practice? What's your experience?
Well, I think it does make a small difference because the court and everyone involved knows beyond a reasonable doubt is a high standard. It's rare that you're going to win a suppression motion, but you will win them. And it does emphasize the importance of the scrutiny that the court should give. So I certainly think it makes a difference, though I think it should be applied. The court should bring a more critical eye overall to suppression issues, but that's my bias. So,
Ron, many judges who have written about motions to suppress and the admissibility of confessions have made the observation that, for the most part, we sit there and listen to the testimony of police officers in many cases who have testified before the court many times, who present themselves well, who give the appearance of credibility and honesty and integrity, and we don't hear anything else. And therefore, what else do you expect besides a ruling that the confession was procured based on a waiver of Miranda and it was voluntary? What do you consider in preparing a case in terms of whether to put the defendant on the stand to try to provide another point of view to enable a judge to make those decisions with perhaps more information than otherwise would be the case?
Well, I've kind of invoked this rule of thumb on putting my clients on the stand. I won't put them on as long as they're breathing. Other than that, I generally tend to put them on. And it's actually held me in pretty good stead, I think, over the years. I'm very hesitant to put a client on because of just exposing them to cross-examination, and in many cases on the good faith basis that I shouldn't have them confess it because they have to testify truthfully. So I think a lot of times, and Denise can follow up on this, I think, when we're confronted with an issue, I will generally assess it with an eye towards a suppression issue. How can I convince the judge that this wasn't voluntary, and do it circumstantially through the either something internally inconsistent in the way that the statement went in, the timing of it, how it happened over a long period of time, the circumstances of it, get the interrogator himself to adopt facts that I can argue it created an environment that didn't lead to my client's voluntary waiver, that the responses appeared to have not been consistent, so it indicates some sort of cognitive dissociation that the client was going through at the time, so that he didn't truly, this wasn't a knowing and intelligent waiver. I generally, I think I take all of my cases and view them through that prism. If I have to rely on my client, I realize I'm going to go down and generally in flames and not do it. And a lot of times it's just because I don't get from the client what I believe would be enough to really tip the balance. Where he's going to show me, well, I was, did he mention the part about where he whipped me? I just don't get that anything sufficient, and I would need such a high level or the case is so hopeless that it's the last shot in the dark, you've got nothing anyhow. But I think you have to assess it, and I think there are enough times, if you can't do it through the circumstances, through your cross-examination, through the circumstances that you can show objectively, even through their witness, I generally think you don't have enough to win suppression anyhow.
Denise, what are your thoughts about that?
Well, there are at least three things that I consider. And is there a chance that the judge is going to believe my client's testimony if he testifies? Is it credible? Is it believable? The second is, if his testimony is believed, will it make a difference? Is it going to be enough to get the statement suppressed? And three is the defendant going to need to testify at trial? Because if he testifies at trial, he can be impeached if he testifies inconsistently with his statement at the motion to suppress. My clients aren't experienced at testifying at trial. They're nervous or testifying at a hearing, and they could slip up, and it could come back to haunt us big time. But you also, if what happened, it's really a balancing test, but if what happened is the client says it happened, and it's egregious, and this suppression hearing is important, you have to really think about it. In the end, 9 times out of 10, I won't put my client on. But there has to be a point where you step back and think about all the circumstances of the case.
Jerry, do you have any thoughts about whether if the defendant testified more often would make any difference? And aside from that, do you prepare every case as if the defendant will testify?
Well, if there's anything I don't like about being in the DA's office is that I don't get to cross-examine people often enough. And I mean, that is the joy of defense work, is that you cross-examine all the time. And we present evidence, and we don't often have evidence that we can challenge during the course of hearings. I work on the assumption that defendants are not going to testify at motions to suppress. I've only had it happen a few times in Superior Court in 20 years. It generally is not in their best interest to do that. I prepare for the possibility every time I prepare for a motion to suppress. First thing I do is get Judge Grasso's book out and check the law and see who's got the burden and make sure the affidavit and all those. I have a checklist that I go through, and then I read the affidavit that was submitted by the defendant, because if it's a motion to suppress a statement or confession, then he's got to file an affidavit, he or she, indicating what the grounds are. And so those facts in the affidavit are sort of the core that I would use to begin a cross-examination of anyone who testified in one of those hearings. And of course, as Denise's first checkpoint indicates, the defendant's credibility at the motion to suppress hearing is a very important issue. And so the scope of cross-examination is expanded a great deal because his or her credibility is an issue. So it broadens the kind of things you can be asking questions about. And so obviously I want to be prepared to be able to question him about facts in the investigation, because it may intersect somewhere with the statement that he made. So those are the kinds of things that I do. But generally I do not expect that there's going to be a defendant testifying.
And just to follow up on something both Jerry and Denise said, the times it is important. You have to make that. You have to have a global view of your case. If you think you want to put your client on in the trial, generally you don't want to give the prosecutor a lot of fodder up ahead of time. So I think a lot of times you have to make that decision with the end game in mind. Even if you think you have a shot at winning the suppression, you may want to sacrifice that, especially unless it's a dispositive motion. You may want to, even if you think it's a client that could perhaps win the day in that, you have to put it into the cost-benefit analysis. Maybe you want to lose this battle, but win the war with the client at the end. I think if you put them on too many times, there is enormous chance for them to be any kind of inconsistency. I think the defendants are viewed differently by jurors. Once they put themselves on they have the obligation. It's no longer beyond a reasonable doubt. They have changed that standard by putting themselves on to who do I believe in this? And so it's a much higher standard. I think we, as defendants, we then have to win the case outright. It's no longer they have to prove it beyond a reasonable doubt.
Now, our time is running out, so before we wrap up, we want to give you an opportunity to ask these distinguished lawyers some questions, so go right ahead. Yes, ma'am.
You have a client who's dual diagnosed for both mentally retarded and mentally ill, who says all sorts of things during the interview, most of which is detrimental. How would you handle that for a motion to suppress? And besides subpoenaing the mental health, subpoenaing school records, all of this, would you do that for the motion to suppress?
Do you want to handle that, or?
The answer is yes. You'd get him evaluated by a psychologist, probably get some neuropsych testing done. You'd get his school records. You'd just explore it from top to bottom. I have a client now who appears to be of low normal intelligence, but tested with an IQ of 50, which is pretty low. So it all goes to voluntariness, and I certainly would explore it. It would depend. It just would depend. My gut would be not to put the person on, but again, you can't just make your decision based on your gut. But why I have the mic, I just want to say yesterday I watched the Frontline program that John Morris mentioned. It's called The Confession. If you go to the Frontline website, you can just click on it and watch it, and it is amazing. I learned a lot watching it. 4 sailors individually gave false confession to a rape murder, and one of the sailors was convinced he had done it. I mean, it was chilling from a defense attorney's point of view, but it I just would recommend that you watch it. It was really an education. It made me think I better be a little more careful.
Other questions? Yes, sir.
Judge Agnes, I just wanted to comment on the issue of voluntariness, that we speak in terms of, in Massachusetts, both the judge and the jury passing on the issue of voluntariness. I wanted to be sure that everyone in this group was aware of the case of Commonwealth versus Miller, 2007, where the appeals court said for the first time that the judge has a constitutional obligation to conduct an evidentiary hearing, because in that case what the judge did was to determine whether the confession had been voluntary on proffers of the defense and the prosecution. It's a constitutional obligation of the judge to conduct an evidentiary hearing.
All right. Other questions? All right, well, thank you, ladies and gentlemen. Thank you to the panelists.